Okay, good afternoon, everyone. Or sorry, my apologies. Good morning, everyone. Thank you to the Committee on Economic Development and Environment. My name is Robert Hawkins. I am the MLA for Yellowknife Centre and the chair of this particular committee. I'd like to welcome the Minister and the millions of subscribers on our social media website following around the world, keeping check as to what we are doing. At this particular point, I'm going to allow members to introduce themselves. I'll begin with my far right, and we'll work our way around the room. So please, if you would.
Thank you very much, Mr. Chair. I am Kate Reid. I am the MLA for Greatsleeve. Thank you for being here.
Good morning. I'm Shona Morgan, MLA for Yellowknife North.
Thank you. Julian Morse, MLA for Frame Lake.
Good morning, Minister and staff. Welcome. My name is Danny McNeely, and I represent the Saukey region.
Good morning. George Nersu, MLA for Mackenzie Delta.
Thank you, members. And today we'll be receiving a briefing from the Minister regarding the Mineral Resource Act regulations from the Minister of Industry, Tourism and Investment. Again, please note that this meeting is being live streamed on the Assembly's social media website, and I would like to remind all members, including the witnesses, to work through the chairs to ensure we have a smooth running meeting, so wait to be recognized. At this particular time, I see the Minister and her staff are ready, so I'll now pass the microphone over to her and allow her to direct or proceed with her presentation as necessary. Thank you.
Thank you very much, Mr. Chair and members of the committee, for welcoming myself and staff to provide this public briefing on the government's progress implementing the Mineral Rights Act. I am joined today on my left by Deputy Minister Pamela Strand and on my right by Assistant Deputy Minister Menzie McEachran, and also have with me today my Ministerial Special Advisor Nigel Woodridge. For decades, mining has been the backbone of the Northwest Territories economy. It has built our communities, created jobs, and driven investment into our territory. Today, as some of our diamond mines approach closure, our resource economy is at a turning point. Our future resource economy depends on how well we transition to new opportunities. The world is looking to the north for our wealth of resources, especially critical minerals, and we have a chance at positioning ourselves as a leader. The Mineral Resources Act is a key part of making that happen. This is not just an update to an old system. It is a fundamental shift in how we manage our mineral resources. It was developed in collaboration with Indigenous governments to create a groundbreaking approach that embeds Indigenous rights into mineral tenure legislation. Now, we are building regulations that will set the stage for responsible, sustainable, and investment-friendly development. We are taking the time to get this right. This is complex work that does not follow a cookie-cutter approach. We are building something different, a modern system that reflects northern priorities, strengthens partnerships, and creates certainty for industry, and we are the first jurisdiction to do this work. That means working closely with Indigenous governments and listening to industry every step of the way. It also means adjusting as we move through the process. A key piece of the MRA is Part 5, Benefits for People and Community. This ensures that companies negotiate agreements with Indigenous governments so communities see real benefits from projects, benefits that Indigenous governments define for themselves. The GNWT will not dictate the content of these agreements, but we will require that they exist and that they evolve as project scopes or scales change. This approach supports real partnerships, not just transactions. I know that change brings uncertainty. Some industry leaders have raised concerns about how these regulations might impact their business. That's why we are working directly with the sector, meeting with the Chamber of Mines and individual companies to also understand their concerns and create a system that is strong and nimble. At its core, the MRA is about creating certainty for investors, for communities, and for our economy. Companies that engage in this system earn social assurance, a key factor to reduce investment risk. I am happy to report the policy work is largely done and the first draft of the regulations are being put together now. Today's presentation will cover progress to date and the path forward in more detail. I am confident that when we fully implement it, the MRA will set the NWT apart as a premier destination for mineral investment. It will foster a strong, secure, and sustainable mining sector that supports jobs, strengthens communities, and ensures that Northerners benefit from the vast resources in the Northwest Territories. Mr. Chair, this closes my opening remarks, and through yourself and with your permission, I'd like to provide a detailed presentation through staff.
Thank you, Minister. I believe I'll be, the Deputy Minister will be leading, so at this point I'll recognize her and allow her to proceed as necessary. Thank you.
Thank you, Mr. Chair. This slide is the outline of our presentation today. First, we'll start out with some background on what has happened since devolution and letting you know where we're headed. Next, we'll focus on improvements that will be seen under the new Mineral Resources Act once it comes into force. Coming into force is the term we use to indicate when the Act and the regulations will be in place legally. The Act is like an umbrella with all of the regulations under that umbrella to build or hold it up. Next, we'll move on to implementation, which is how we get these multiple new regulations and new sets of rules into place. We'll talk briefly about royalty regulations, which is the money side of things. We'll explain a few regulations that will be in a phase 2, and also we'll cover off what is in phase 1 and why. And finally, with the implementation timeline. This slide shows a timeline. I'll draw your attention on to two things. On the bottom of the process is the process that has taken place to manage our own NWT land and resources on the top. The evolution of the, on the bottom is the process since devolution. On the top is the evolution of the mineral resource. Let me get my, sorry guys. Okay. Got it. Okay. The top is lands and resources. I'll go through the bottom first so that you can see the general process, and then I'll discuss where and how the MRA, the Mineral Resources Act, and those regulations fit into the process. In 2014, the NWT Lands and Resources Devolution Agreement transferred responsibility for management of lands, resources, and rights in respect of water from the federal government to the GNWT. As part of devolution, the Intergovernmental Council was established as a forum for public and Indigenous governments to cooperate and coordinate on matters related to lands and resource management, while respecting the authorities and jurisdictions of each signatory. The Intergovernmental Council, or the IGC, played a leading role in the development of the Mineral Resources Act. Once work began on various initiatives, it was recognized that a more efficient and formalized process should be applied. This led to the development of the IGC Legislative Development Protocol, a groundbreaking protocol, frankly, that was released in December of 2020. Why it's groundbreaking is really because nothing like this exists in Canada, where the process is formally laid out for how Indigenous governments and organizations and territorial, provincial governments can work together on legislation. Part of this protocol is to develop a technical working group, which we often refer to as the TWG, which develops jointly policy for specific legislative initiatives. In 2022, IGC invited all NWT Indigenous governments to participate in the collaborative development, regardless if they had signed on to the devolution agreement. Prior to finalizing our legislation, IGC will review and support the proposed regulations. Now looking at the bottom, you can see that prior to devolution, the administration of minerals was governed by the federal government. In 2016, after devolution, we went through an intensive engagement process to determine what was important to Northerners in relation to minerals. Through that process, the MRA was developed and passed in the legislature in August of 2019. We then began the process of developing the regulations. This has been a collaborative process with GNWT and Indigenous governments at the technical working group table, as formalized by the protocol. We have been working diligently at this table, meeting 1 or 2 days per month for full-day meetings since 2021 to develop the regulations, which are expected to be internally drafted, which are being currently internally drafted. After drafting, final engagement is required, and this will be followed by Section 35 Aboriginal consultation and a few more steps, such as the order of the commissioner, in order for these regulations to come into force and into law. Now, why are we evolving the mining regulations? This work is actually to ensure that the legislation meets the needs of the Northwest Territories. This slide refers to sustainable mining governance. There is an international forum of mining, minerals, and metals that has now become the leading global intergovernmental policy forum on mining and sustainable development, with over 80 countries participating in knowledge sharing. These members produce this framework to help guide governments to ensure that their mining sectors contribute to sustainable development. As a policy guidance tool, this framework outlines the governance through the full mining life cycle with respect to environmental, social, and economic governance, and promote the generation and equitable sharing of benefits in a manner that will contribute to sustainable development. As you can see on this slide, it's divided into 6 pillars. 1, laws, policy, and institutions. 2, financial benefits. 3, socioeconomic benefits. 4, environmental management. 5, post-mining transition. And 6, artisanal and small-scale mining. I'll now walk you through where we currently are and where we are going. As you can see on this slide, under the current mining regulations, the GNWT manages within 2 pillars only. Those are identified as pink on the pie chart. This consists of laws and policy for collecting and publicizing geological data, for example, and the basic rules of administering mineral tenure, such as mineral claims and mineral leases. Secondly, the financial benefits pillar, which really relates to the royalty regime, with minimal transparency in which GNWT reports those results aggregately on a territorial level. I'll just briefly refer to the other portions of the pie chart. As you all know, environmental management is addressed through the co-management regulatory environmental processes under other legislation such as the Mackenzie Valley Resource Management Act and Territorial Land Use Regulations and the Waters Act. Socioeconomic benefits in purple are somewhat addressed during the environmental assessment processes and somewhat also with socioeconomic agreements. We are evolving the mining regulations to be more comprehensive in this regime. So on this slide, you will see where we are moving with respect to the Mineral Resources Act and it coming into force. The modernization of this legislative regime does fill in some of the gaps and provide for more sustainable governance. This includes significantly increasing access to geological information, coordination, governance between various territorial and federal regulators, modernizing the legislation to be more adaptive, and also working in increased engagement and consultations, particularly in the earlier stages of exploration, and adding furthermore on the financial benefits piece, such as increased administration and tracking of minerals produced, introducing a production license for the actual removal of minerals, and better management and distribution of benefits, and transparency with respect to data from royalty and production. Under socioeconomic benefits, as the minister referred, the GNWT is creating regulations for benefit agreements and socioeconomic agreements. And lastly, for artisanal and small-scale mining, the regulations are being adapted so that we can address smaller scale operators to recognize their contribution to the economy without the necessary expense and requirements that a large development must go through. And also with respect to, an example of that might be simplified reporting and simplified forms. So, Mr. Chair, I'd like to pass the presentation over to Menzie McEachern for the balance.
Thank you, Deputy Minister. Assistant Deputy Minister, when you're ready, please.
Thank you, Mr. Chair, and thank you, Deputy Minister. So the Deputy Minister touched on a number of the high-level benefits that the sustainable sort of governance regime that the Mineral Resources Act embodies will bring. Sorry, what? The little bubble. Oh, okay. And just kind of diving into a little more detail on some of those benefits. Really, well, starting from the top left of this slide, one of the key benefits is that there is increased opportunities for relationship building and knowledge sharing between mineral exploration and mining companies and Indigenous governments and organizations. Historically, we know that information may not have been a focus in the industry, and local people often didn't know exactly what was happening on their traditional lands. Times, of course, have changed, and information is being shared as we speak. That said, once the new MRA regulations are in place, this process will be formalized, and information will be required to be shared throughout the mining project life cycle. This information sharing will allow for early and sustained relationship building, those important conversations through a project's life. The Deputy touched on this, that there will be increased publicly available geoscience data, and this will help industry and government understand, or governments understand, what we have in our territory in terms of geological potential. Currently, only 5% of the data collected is shared with governments, which makes it very difficult to pass on knowledge as mineral claims change hands and as we seek to attract exploration investment into the territory. Furthermore, there will be increased public transparency through an online public registry. Members from the public will be able to see many more details than previously through this system, and that will help build trust in our administration of mineral projects and the sector. There will also be increased tools for companies to manage their own tenure. For example, the new online information system, which we call the Mineral Administration and Registry System, will be more flexible and allow individuals, i.e. prospectors and companies, to have more control and more information regarding their mineral interests. Pam touched on the mandatory benefits requirements to occur for producing mines. Now, although agreements already exist in the form of impact benefit agreements between mining projects and Indigenous governments and organizations, the process to this date has not been formalized. So once these new regulations are in place, these will be required by law, these benefit agreements. There's also going to be increased monitoring of production activities and data, so there'll be greater awareness of what is happening in the sector and regarding our producing projects from all those that have a stake in that. Modernization, was also flagged internally as well as through external engagement as a really important piece of the Mineral Resources Act. One of these modernization elements is to have online map staking, as has been touched on, and which I'll get into a little bit further as well. And that is something that is a high priority for us in terms of moving into modern alignment with other jurisdictions across Canada, and certainly something that's in high demand among our mining sector companies, who no longer will have to fly out to remote areas and physically put claim stakes in the ground. So let's dive into a bit of process information here on how these MRA regulations are being created. It's kind of helpful to see these chunked out into phases because there's a lot of meat here. And we, with our current resources, can only tackle big chunks at a time, and this is what you see laid out here. So we've started with 5 main groups of regulations. You'll see on the top left, it says MRA coming into force. So to bring the act into force, these are the nuts and bolts regulations to make it happen. And these 5 categories of regulations are as follows. The general administrative regulations are essentially the mineral tenure administration regulations, which covers mineral tenure throughout the entire project life cycle, from mineral claims to leases to production licenses, etc. And the second chunk of these first phase MRA coming into force regulations are the socioeconomic and benefits regulations. And then there's also the capability with the Mineral Rights Review Board to resolve disputes, and so or conflicts. Then there's also going to be mirrored royalty regulations, largely similar to the current royalty regulations, although with some modernization tweaks and fixes. And then to cap things off in this chunk will be the transitional regulations, ensuring a clear transition into the new regime from historical tenure regimes. Then we have this second sort of label, the royalties framework enhancements. It has been operating independently, but in parallel with all of the other coming into force regulations I just spoke to. And that is anticipated to come to be implemented soon after those phase 1 regulations brings the MRA into force. And that, I'll say a little bit more about the royalties work on a future slide. And then the third sort of bucket we have here is what we call the phase 2 regulations, which will include the 3 thematic areas listed on the slides. Zones, which are basically incentive zones for explorations. Temporary restricted areas, which puts short-term restrictions on specific areas as nominated by Indigenous governments until those areas can be more permanently protected. So very culturally or traditionally sensitive areas that have been identified. And then last and certainly not least, the online map staking functionality. The Deputy Minister spoke earlier about the Legislative Development Protocol, and it is quite a formal protocol. It's broken into a number of steps, A through G, as you can see there in the left-hand column. And we have to, and we do follow these steps throughout any land and natural resources legislative or regulations project to get to the finish line. And so for both the phase 1 regulations, royalties, as well as phase 2 regulations, we go through this step by step. And in fact, we have made it through many or most of the steps for the work we've done collaboratively with Indigenous governments so far. We're currently in our phase 1 regulations. We're at step F, which is the collaborative development of those of the draft regulations. And similarly, we've marched through all those steps also for the phase 2, although the actual regulations development for the phase 2 regs is going to happen after the phase 1 regs. We're up to our eyeballs right now with those phase 1 regulations. Zooming in a little bit on the step E, which is the technical working group. Deputy spoke a bit about this earlier. It really, it's a special sort of mechanism or group in that, yes, everyone, all of the Indigenous governments, as well as GNW2, that have signed on to the devolution agreement are at that table. Their representatives are at that table, rolling up their sleeves and developing the policy and regulations for a particular initiative. And currently we have 12 Indigenous governments participating in this. That's actually more than the devolution agreement signatories. Why? Because it's been an open door invitation to all Indigenous governments to participate in this process. And they don't need to have signed on to the devolution agreement to do so. And since that has been an ongoing and open offer, 3 additional Indigenous governments have decided to join the fray. Looking a little bit more in detail at Step F and Step G in the Legislative Development Protocol. Step F is where the majority of the collaboration occurs. This step expanded from when the technical working group was originally assembled and will actually be in place right up until a near final regulation is shared and supported by the technical working group. So Step F is a really long-lasting step. It takes into consideration all the public engagement and feedback from as well as Aboriginal consultation input received, and how best to address that engagement and consultation input. Collaborative development of the policy intentions to support regulation development has been underway since 2021, when the TWG was originally established. It has been a really extensive, in-depth process with literally hundreds of hours being spent listening to technical experts, deliberating, deciding on each policy and regulation across all the different thematic areas. And throughout the process, engagement has been taking place with the public, regulators, as well as, of course, industry representatives. We've also met with Indigenous governments who've not been at the technical working group table or were not at an earlier time. And that engagement has been happening both online as well as in in-person meetings, letters, as well as online surveys. Feedback from all that engagement has been brought back to the technical working group table and has influenced and informed the development of the policies. And the last point of engagement will in fact be when we formally and publicly post the near final regulations, which will follow Section 35 Aboriginal consultation. Well, we've spent quite a bit of time talking about the regulation development process itself and the sort of meat and potatoes of what the regulations cover. That said, that's only part of the story. In order to implement these regulations, and when I say implement, I mean operationalize them in day-to-day business, we have a whole bunch of extra implementation planning and execution work to be done, as this slide shows. So we need to resource the thematic areas, the functions where new responsibilities are assigned or obtained. So that means we have to do organizational design and organizational change work. We need to develop new business rules for our organization, business processes, workflows. We need to update software information systems. I spoke earlier about the Mineral Administration and Registry System. So this is an online, modern information systems tool, moving us away from a paper records-based system. We need to develop external guidance documents. It's not just us internally that's changing things. It'll be new processes for companies, for Indigenous governments, and guidance will be needed in that regard. And then furthermore, we also have to help all those that will be implementing this, both in industry and Indigenous governments, to to resource and to operationalize their work, so the external engagement will continue. Just a little bit more on the royalty side of things. Firstly, I mentioned that the initial step will be the mirroring the current royalty regulations with some tweaks and improvements. Then, right now, as we speak, we're engaging with industry on the proposed changes to the royalties framework, including allowances and deductions to royalties. Also, it could be considered as incentives within the regime. And then we will create a policy intentions document that will inform the development of the royalties regulations themselves. Furthermore, we'll also be getting an independent third party to review our royalties modeling and analysis. And that third party independent review will be available publicly, anticipated later this year. Touching a bit on the Phase 2 regulations, we are currently developing the policy intentions for these enhanced online mapping tools and the integration of these tools into regulations, as well as, of course, into the design of the mineral administration and registry system. Once we're not so super busy with the Phase 1 regulation development, we can turn our attention to these regulations. And we're also working on contracting for the system changes required to update the associated online information system or tool, the MARS system. We're getting very close to that sort of design build contract with a vendor, and these regulations will be developed, as I said, after the general regs are complete. The Deputy Minister earlier spoke to what these various Phase 2 regs content-wise mean and why they're important, so I'll skip that bit. And this is a bit of a busy slide. Apologies for that. What we would like you to take away from this slide, which is the timeline for implementing the regulations, is just the understanding of how many pieces are required to get these new regulations developed and in operation. We've spoken to many of these items throughout the presentation today, like the collaborative development process. There you can see as a blue bar, the amount of engagement that's taken place throughout the development of the regs, the green bar, and then you can see that the final Phase 1 regulations are expected in 26-27, with coming into force of the Act, with the various other implementation elements ready to press go on in the summer of 2027. The implementation side of the regulations are all those red bars that you see in front of you. So I did speak to these a few slides earlier, but here you can see how long it takes to get everything in order to make sure that the regs can function properly. The first bar are the external change management activities I mentioned earlier that we've been heavily involved with and will continue through the implementation process to get people ready for the change. And also, helping folks interact and use our fully automated online system. The second line is making sure there are documents in place to understand the new way of doing things. I mentioned guidance documents, and those will be available online as well, not just in old school print. And the next few red bars show the internal work that we're doing to prepare for all of this, so that our team can operationalize this day to day. And that includes, some changes to job roles. People are doing some new things that they don't do today. And that requires training as well for our folks on new roles and functions. And then, of course, along with all of that comes a number of resourcing questions in terms of how all that can be resourced to make sure We can do this and other work that we currently are responsible for in the department. And you can see there at the very bottom of this slide the intensive work it takes to build that mineral administration and registry system. So I think, Mr. Chair, that probably is a good moment to end the slide deck and turn it back to yourself.
I'll just turn it on. All right, thank you. I think we're having minor technical difficulties, so we'll certainly work through our best, and hopefully our millions of subscribers will appreciate the fact that technology, as wonderful as it is, does have the occasional hiccup. All right, I'm now going to open up the floor to questions. First, I will have Ms. Kate, then followed by Mr. Julian, and and Mr. Danny and Ms. Shauna. So, looks like everyone wants to jump on board with some good questions, so I'll begin with Ms. Kate, please, when you're ready.
They are working. Okay, thank you, Mr. Chair. And thank you for letting me go first. I have a hard stop for a mandatory meeting. I've spoken to the minister about this previously, but I'd like to get it in the public record. But as the minister knows, I've heard from constituents who are involved in the MRA development process that the active mines that we have in the Northwest Territories would not be allowed under the revised MRA. So can the minister explain why this may be and what limitations is industry saying or opposing the amendments in this regard? Thank you, Mr. Chair.
Thank you. I'll go to the minister unless she directs otherwise, as a standard, so as we usually do, the finger pointing or directing. So I'll allow her to direct traffic, obviously, as necessary. So, Minister, if you would.
Thank you very much, Mr. Chair. Mr. Chair, I'll start, and then I'd like to pass to my colleagues who are actually the ones at these tables for further detail. But essentially, our goal is not to stop operations, not to stop prosperity in the Northwest Territories. The goal of this work really is to modernize the legislation so that at the end of the day, we are putting into our legislation what we expect in the territory. And so our goal is absolutely not to see mines not operate. I think that we're certainly in a period of transition and change. It is not my understanding that none of our mines would be able to operate. In fact, some of the conversations we're having are how to transition our existing mines into this new legislation to make sure that there is a path and a process to easily be able to do that. So that those are some of the conversations that are happening, and our existing producing mines should absolutely be able to continue to produce once this legislation comes into force. With that, Mr. Chair, I would like to be able to pass the floor over to Deputy Minister Strand for further detail.
Thank you for that. Deputy Minister, if you'd continue or help enlighten us.
Thank you, Mr. Chair. So as you've heard, as the minister, the intention is that the currently operating mines are continue to operate on day one of the Mineral Resources Act coming into force. So there's a lot of misinformation, I think, circulating around. What we have is trying to figure out how to transition existing tenure into the tenure under the regs. For example, the production license is a new instrument. We don't have that right now. And so how do we transition current operators to obtain that or, just receive that? We need to figure that out because it's not ideal to be running two separate mineral tenure regimes, the old one and the new one at the same time. So those are the intricate complexities that we're working through right now. Certainly, we've met with all of the producers. We are fully open to continue to meet with them, but I'll just re-echo the point is we're just trying to figure out, under the regulations, what those transitional provisions look like. Thank you, Mr. Chair.
Thank you for that. Ms. Kate, anything further?
Thank you, Mr. Chair. Yeah, so could you speak a little bit more to these transitional complexities, if it's possible, in sort of plain language, what you're hearing from industry specifically on core issues that are flagged as problematic for them? I would love for the public to understand this better. Thank you.
With that, Minister.
Thank you very much, Mr. Chair. So a great example of that is currently our existing mines have benefit agreements, and how do we transition those benefit agreements that existed previously into benefit agreements that would be existing under the new legislation, for example. One of the things that we're making sure of is that Indigenous governments and industry are both basically walking together into this new legislation confidently and together, and how do we support those relationships to be able to transition over through those benefit agreements. You know, we hear often a call for grandfathering, and need to make sure that whatever that looks like is widely accepted. The other piece of that is royalties, and so how do we transition people from an existing royalty system into a new one, and what does that transition look like at the end of the day? Those are probably the two greatest examples that I would have for the member. Thank you.
Thank you. I'm going to ask, I forgot to ask, did we want to do time or two questions? I'm just going to ask you, did you, Ms. Kate, have anything to clarify? I know you have a hard stop, and so hence I'm offering you the, please.
Thank you for your allowances, Mr. Chair. So that's good to know. I'm wondering then, can we be more specific about the transition on the royalty system? Are we seeking more royalties from industry? Can we be clear about that? Thank you, Mr. Chair.
Please.
Thank you very much, Mr. So on one of the slides, you saw phase one and then royalties in the middle, and then phase two coming afterwards. So that work is work that is currently underway, and that is work that we're expecting to have available publicly in the fall of 2025. Thank you.
Thank you for that. I now have Mr. Julian, followed by Mr. Danny, Shauna, and then, and of course, we'll continue to other members as they express interest. That said, please.
Thank you, Mr. Chair. Yeah, I just had my first question answered, so I'll just want to confirm that one again. But yeah, I've got a couple of constituents who have been very interested in when kind of the public's going to get an opportunity to comment on this. So I heard that the draft regs are going to be released in fall 2025. Is that correct? No? Okay. So
Can you, the public can't see your nod, so Minister, if you want to put that on the record.
Thank you very much. So the specific question from the member was in regards to royalties. So just to clarify, that was what I spoke to about fall of 2025. Thank you.
Okay, I wouldn't normally engage this way, but the public can't see nodding and whatnot, so that's, okay, so.
okay, in that case, thanks for the clarification. So what I'm interested in knowing is when you put the public engagement slide up, there was a very small little green square. That is the thing I wanted to ask about, and that is when the draft regs will be released publicly, will the public have an opportunity to comment on them? Yeah, that's my first question. Thanks.
Thank you very much, Mr. Chair. So, Mr. Chair, the intention is to begin the engagement process for the regulations in summer of 2025. That's when the public will see a final policy document. But from there, in addition to engagement, there is also Part G of our IGC protocol. And then in addition to that, there's also Section 35 consultation that has to take place. So there's a number of review portions or review processes for this document to go through publicly with Indigenous governments and with our partner Indigenous governments for devolution as well.
Thank you for that. Anything further from you, Mr. Julian, please?
Thank you. Yeah, and I just want to be clear, like it does look to me from the slides that you shared that the engagement with Indigenous governments has been quite robust and extensive, and they've been on the technical working group. I was specifically asking about members of the public who aren't, who don't fall into that sphere. So kind of public engagement itself, like opportunity for the public to see the draft regs and to comment on them. So Yeah. The next question I had was about the royalty framework enhancements. Can you describe the process which is going to take place when you go through that? Is the goal of this process going to be better capturing benefits from industry? I know that's a concern that's been raised in the past. Well, I'll ask that question first. I do have follow-ups from that too, but.
Thanks. And we're going to try to stick to the two-question area, so if to expand a bit, we'll figure it out, but I want to make sure we get around the room at least once. Thank you.
Thank you, Mr. Chair. So, Mr. Chair, just the member did ask a first question before he got into the second piece then, which was, yes, there is a policy intentions document that will be released that the public can see. Once then, there's the opportunity to go through the step G of the IGC protocol, and as well the Section 35 consultation. There will also be public engagement, and public will have the opportunity to weigh in on the regulations as well. And then in regards to the other piece, I'll pass to the Deputy Minister. Thank you.
And thank you for that, Deputy Minister, when you're ready. Thank you.
Yes, further to the member's questions in regards to the royalty regime, the first thing that we've put out a number of public documents with respect to this. So the first is looking at the type of regime that we have. For example, we have a profit-based regime, and what you'll see most jurisdictions across Canada have gone to a hybrid regime where there's a profit-based component and then a royalty, a certain percentage of that's paid annually, and those are what are quite common. So we've looked at the structured regime firstly, and then I think secondly, transparency. So we've met with producers about more transparent information that we know has been always something that the public has asked for. What we will look also at deductions. What deductions are eligible in a royalty regime. For example, one might be if a mine is close to town and they invest in public infrastructure, whether it's road or energy, can that be eligible for a royalty deduction? So we want to be very progressive in how we look at the regime. And then lastly, once we have all that put together, we will be doing modeling of this, and that modeling work will be released publicly, as the Minister said. We're hoping for that modeling to be released in the fall to the public. And of course, this is all subject to approvals as well. Thank you, Mr. Chair.
Thank you, Deputy Minister. If we're good, we'll go to Mr. Danny, and we'll continue to work through those from there. So please, when you're ready, sir.
Thank you, Mr. Chair. My first comment is, I think the department for progressing on the finalization of this regulation process. As you know, the legislation was adopted in the 18th Assembly, and the regs have been worked on since then. Now we finally see the light at the end of the tunnel for this conclusion. Not only to satisfy ourselves, but to satisfy the players as well. They want to know what the new rules are. And I see some changes here, and some changes to royalties, when at the time, the minister is correct in saying you want to modernize your regulations. That was the intent said in 2019. You want to modernize. Now I'm given the impression there's some additional changes. And if I was a mining company, I'd say, well, I worked diligently in providing my opinions to the 18th Assembly, and now I got to do it all over again. So when are the rules going to quit? So I just recognize that. And I'm eager to see what new changes on the royalty parts are going to look like. And if there's going to be needed legislation to change that. And also, that's just a point of notice there. And when I look at page 7, I think it is, page 7 on your pie chart, we have a system in place already for developing an access and benefits agreement. It's within the Sawtooth land claim, which is similar to the other three. So that system, or that provisions in chapter 21 and 22 and 23 sets out the rules for developing an access and benefits agreement between the Sawtooth land claim and the proponent. So maybe some of those provisions could be looked at to include in here. This way we can tell a mining company that's looking at Contoito Lake, for example, well, we utilize similar provisions in other regulatory access, such as the other land claims, to incorporate that into here. I just hope it doesn't go to the point where if I'm a mining company and a community, we're developing and negotiating our access and benefits agreement or our IBAs. And along comes government as a third party to say, you know, these are our rules. And if I was one of the local leaders, I'd say, can you please stay out of it? We are negotiating this in compliance with what you have there already. So I think maybe some words of leniency and compliance, because it's going to be done. There was an oil company that wanted to go into the Colville Lake area there years ago, and they were told by the agency to go back. You don't have access and benefits agreements, so go back and negotiate with the appropriate Indigenous governments and then come back. So they put a stop to that, which is good. You have to get it done. So I just share the experience in that point number 3 in the pie chart there. Socioeconomic benefits could be designed to bring some comfort, to bring and defy modernization and certainty to both stakeholders that are looking at pursuing the necessary permit applications for their project. And my other question, not so much just aside from my reviews or suggestions, is it part of the regulations to set up a industry secretariat office? So if I'm a mining company coming off the plane there from Vancouver, I can go to that liaison office, which represents all stakeholders, including the Indigenous organization. So it becomes a one-stop shop. We had that similar back in the 80s. It was called the DIS group, Development Impact Zone. So the oil companies would go there and meet with the staff, and then the staff would communicate and set up meetings with the appropriate individuals. We didn't have a land claim at that time, so that was sort of the regulatory system. Are we going to have a one-stop liaison office here, or a secretariat, a mining Indigenous secretariat? Thank you.
Thank you, Mr. Denny. Minister, if you would, to his questions and overall challenges that he's described. Thank you.
Thank you very much, Mr. Chair. So there was 3 key items in there, and I'll try and go through them as quickly as possible. In regards to royalties, our goal is to always stay competitive. We acknowledge that the NWT is, or the North in general, the territories are a more expensive jurisdiction to do business, and want to ensure that we're not setting ourselves apart in regards to royalties and making it hard for people to do business up here. So that's certainly something that we take very seriously when considering royalties. The benefit agreements, Indigenous governments at the table, in Sawtooth Secretariat is certainly at the table doing this work alongside us, and Indigenous governments worked very diligently to ensure that benefit agreements were included in the regulations, but it is not, the benefit agreements are a partnership between Indigenous governments and the mining company. It is not, the GNWT is not there to read through a benefit agreement to say if it meets the cut or not. It is simply do you have a benefit agreement, and are Indigenous governments on side with it? It is the Indigenous government who sets the benefit agreement and the details of it with the mining company, and it is not our space to be involved in the content of that. And that is something that we need to be very respectful of, that it is a partnership between the mining company and the Indigenous government. So from the perspective of the GNWT, it is somewhat of a box-checking exercise in order to respect that autonomy. And then the last piece there, in regards to an industry secretariat, certainly outside of the scope of the regulations and the Act itself. However, ITI does have pathfinding services and engagement specialists as well that work within the department. In addition to that, the Minister of Environment and Climate Change and I have been working very closely together really to identify places for key wins for our mineral resources sector in the territory, and understanding that we do have a different landscape in the Northwest Territories when it comes to mineral resource development. What we've been working to do is bring together the key entities to the table. So for example, Industry, Tourism, Investment, Environment and Climate Change, Mackenzie Valley Land and Water Board, Mackenzie Valley Impact Review Board, to make sure that people do have a like the member said, a one-stop shop where they can access all of that information. So that is something that we, through our officials, are working on at the moment. What that looks like at the end of the day is still to be determined. And given that a lot of these companies aren't based right here necessarily in Yellowknife, and a lot of our projects are happening clear across the territory, ensuring that that information is available virtually is going to be paramount. Thank you.
Mr. Danny, I think further, and I should note the time before I go to Mr. Danny that we've got about 15 more minutes on the clock for time, and we still have one more member, at least. Thank you. Mr. Danny.
Yeah, thank you, Mr. Chair. Yeah, recognizing our timelines here, I just request, the ADM had mentioned that there's going to be a third-party individual or firm looking at the royalty review. If the minister would share that publication after it's done. That's a request for information. And my last question is, I see a real unique opportunity particularly with the trades discussions going on with our American counterparts, which increases a high demand for your minerals, and the tabling of the new regs complements that demand. And I see a lot of excitement that could come about your trip at PDAC. So recognizing all that and looking at the steps in review of engagements and marketing and promotion of these regs, I think is really complementary to the dispute that's going on. Wherever there's a demand, there's an opportunity, and I see good, positive things by this process. Now to market that process, to share it. So I just point that out as a complementary kind of step-by-step process in our resources and our responsible resource development, and in particular the creation of opportunities, which the North really needs at this point in time. They're missing.
Hearing largely a comment, if the minister would like to respond. Okay, and then I'll proceed to the next member, please.
Thank you, Mr. Chair. So quickly, I agree with the member that it's important that information like these third-party reviews are made public. So you have my commitment that information will be shared publicly. In addition, when we have the opportunity to participate in Geoscience Forum, in Roundup, in PDAC, we talk about our work within our MRA and the regulations that go with that. At every turn that we take, I had the opportunity recently at Roundup to sit on a panel with both Yukon and BC. and speak about this work that's being done. I'm quite proud of the Northwest Territories as being leaders in this work, and we've had other jurisdictions reach out to us who want to learn about how the NWT is doing this work. And I am nothing but happy to share it because I think it's incredibly important that we move forward as a country and how we do business on Indigenous lands. Thank you.
Thank you for that. I now have Ms. Shauna as the next person.
Thank you, Mr. Robert. Okay, my first question, there was mention in phase 2 at looking at incentive zones for exploration. Can you explain what that might mean? I'll start with that one. Thank you.
Thank you. I'll now go recognize Assistant Deputy Minister, and the mics are live. So.
Thank you for the question, Mr. Chair. These zones are essentially incentive zones, and so they are parts of the territory where one or more Indigenous governments could say, hey, we want to see exploration happening here. We want to attract exploration to this area. And so then it gives the opportunity of saying, okay, well, what in the sort of policy toolkit could be put in place to further attract mineral investment into a particular zone? So there are these types of zones exist in, say, other countries to promote or to attract investment into various industries or into various parts of a value chain. Like some jurisdictions want to create like a manufacturing zone of investment, and then so they provide certain incentives to attract that type of activity. So this is that sort of a concept of how to make things more attractive in a particular place. And of course, it would have to be with the support or with the request of an Indigenous government that really wants to see that type of activity there. Thank you.
Thank you for that. Shauna, when you're ready.
Okay, thank you for that. Can you also clarify around phase 2 in general? I noticed that phase 2 is not specifically labeled on the timeline in terms of when it's going to be rolled out or implemented. And I also noted that the online map staking functionality it's not supposed to come into effect until phase 2. Can you clarify where that can be expected on the timeline, phase 2 in general, but also specifically the online map staking functionality? Thank you.
For that. Ms. Minister.
Thank you so much, Mr. Chair. So that work is targeted for within the first year after coming into force of phase 1. So we're looking at the 27-28 fiscal year.
All right. If you're good, I'll move on to phase 2 unless you need a clarification question. Shauna, did you have something?
No, I have a question.
Oh, sorry. We're trying to work off 2 questions around. So, so I think Mr. Julian had another question, and we'll try to get it through so we can get people. Please.
Thanks, Mr. Chair. I'll be quick and just ask one to allow other members to ask another question at least. Yeah, I'd just like a little bit more detail on the kind of public review of the draft regulations. I did hear the minister say there's going to be a review of policy intentions. That's quite different from the draft regs themselves. And I think I did hear you say that the public will have the opportunity to engage on the regs themselves. Could you just describe what that process is going to look like and just reassure the public that they will have an opportunity to see the draft regs, comment on them, and get responses from the department and see those comments reflected? Thanks.
Thank you. I believe the minister, Assistant Deputy Minister will take that question. Thank you.
Yes, thank you, Mr. Chair. So what we'll be releasing is a very detailed public engagement document with all of the policies that the regs are based on from A to Z clearly spelled out every single policy topic with the rationale. It's basically like reviewing the draft regs, but not in pure legalese. So it's something that both industry as well as the public can say, these are the policy decisions, these are the content, these are the reasons for doing these things across every single scope element of the MRA regulations. Now, that will be the primary flagship opportunity for feedback from industry, from the public, from everyone who has a stake in this. And so that the input will come back to us and the technical working group. That can inform changes to draft regulations. And then from the revised or the informed draft regulations from that public engagement process, those will then go out to Section 35 Aboriginal consultation. And then there will be input, of course, back from Indigenous governments through Section 35 Aboriginal consultation, leading to more changes to the draft regulations. And at that point, let's call them near final draft regulations will be officially posted for that, public posting and comment period. So that said, that's pretty far down the line process-wise, and the regs hopefully at that time will be near final. So, the intention with the very detailed public engagement paper is that there will be an opportunity earlier in the process to provide really meaty feedback to the draft regulation process. If we don't release something like that public engagement paper earlier on, and then after Section 35 Aboriginal consultation, post the near final regs at that time, really how much opportunity is there for significant changes at that point in time? So we see this as an innovative approach to ensure that input comes in at an appropriate time where it can be incorporated into the regulations themselves. Thank you, Mr. Chair.
Thank you. I'll go to Ms. Shawn for the last question if she'd like. And then I've saved a couple for myself at the very end, and then we'll work towards a wrap up. Thank you, Ms. Shawn.
Thank you. So you had mentioned that one of the goals is when mining ownership changes hands, that you want to increase transparency and information sharing. I think I heard you say, at least to government, when there's those kinds of changes in ownership. Will it also be worked into the regulations that more information around changes in mining ownership will be available to the public? Or is the idea to just ensure that the government will be able to hold more information about those kinds of business transaction and shifts in ownership and implications? Thank you.
Minister, if you would.
Thank you, Mr. Chair. It will be public.
If there's nothing further, I can move on to just a couple. I think I have two questions just for clarity. Save them. There we go. Let's start with, I think it's slide 12. Yes, slide 12. You don't have to go to it per se. It's just on slide 12, you talked about the collaborative development and working with folks, including the technical working group with Indigenous folks and governments. One of the constant themes we'd heard in our regulatory discussion over the last year and a half was the ability to engage properly with these types of initiatives in a balanced way, in a timely way. How are these needs being met in that regard? Because some of these Indigenous governments, even and folks working together, I mean, are they able to bring the capacity and skills, and are they able to, is the government supporting them to do this? Because we're hearing it is a challenge on their side, so how are we meeting these objectives? Thank you. Minister.
Thank you very much, Mr. Chair. So, Mr. Chair, this work is largely being done through the Intergovernmental Council protocol. And so there's an Indigenous government caucus that takes place there. And they are able to all support one another through each Indigenous government. They choose who they would like to have participate and would like to have at the table, so they select. And what it also comes with is funding to participate in that process. And so I think that's a key component of the IGC protocol is that funding piece. And so some Indigenous governments have, for example, their lawyers that participate at the table, but who they choose to have at the table is 100% their decision. Thank you.
Thank you. It wasn't a principle based on who gets to be there representing one group. It's the ability to fulsomely participate, and that really is the crux of the issue. And we're hearing that, and that's the crux of the issue I'm trying to carry forward, that, you know, it's meaningful participation, not window dressing. So, and furthermore, in all fairness, we don't want people who cause delays because they can't participate. It's outside of their ability or scope of without revisiting too much, maybe one of the last areas I'll ask is, so how mining exploration can be supported through the new MRA regs? And we hear some concerns about parts of their life cycle, investment, and overall participation. Any thoughts on that?
Can you repeat the question, please, Mr. Chair? I had a hard hearing you at the end there.
Yeah, could be a little bit of the issue of under the weather. So how mining exploration will be supported through the new MRA regs? And think of it as a big one. There's going to be some transitions, processes, and whatnot. So how do you see them being supported? Thank you.
So thank you very much, Mr. Chair. So just in regards to your comments around your first question, I also wanted to let you know as chair that in conversations that I have had with different representatives from Indigenous governments, part of the importance of accessibility to this work is ensuring that the speed is also respected, and ensuring that there is time to go through this in a methodical way. And so just wanted to share with yourself that I have heard feedback from from Indigenous governments that they appreciate the fact that they've had added time to work on the regulations. In regards to your question around the claims and the leases process, this certainly does give longer periods of time to explore land and find an economic mineral deposit, which is very important. And I think for further detail, I'd like to be able to pass to the Deputy Minister, who can go through kind of the into the weeds pieces.
Deputy Minister, when you're ready.
Thank you, Mr. Chair. We've seen a trend across Canada where, right now under our current regime, you have 10 years on a mineral claim, and after that you're forced, no other options, to either take it to a lease, which requires a legal survey, which is quite costly. We've heard from industry, there are concerns with that process. So what we have right now embedded within the new Mineral Resources Act is a mineral claim life of 30 years. Nunavut, very similar, made those changes in the Nunavut as well. So that allows a longer runway for companies to explore a claim without being forced to take it to a mineral lease. But it doesn't prevent somebody that wants to fast-track their project. You can apply for a mineral lease whenever you want, whenever your project is ready to advance to the advanced stages of the lease. So we believe that provides flexibility to industry and leaving, those decisions with how fast their project advances. Thank you, Mr. Chair.
Thank you. All right, I'm going to wrap up. One thing I'll mention is perhaps if it's possible to put the presentation on your website. I'm not sure if it's publicly available in that manner. I mean, we just publicly put it on the social media site of the Legislative Assembly. And as the Minister knows, we have millions of subscribers here daily. I mean, in real time, we're getting tons of feedback. But in all seriousness, if we're able to do that, that would probably be helpful for those who want to track it. But I'll leave it at that, at your discretion at this particular time. That said, I wish to thank all our witnesses for presenting today. We know you had to sneak off due to other commitments, and hence we'll bring it to a close. And so at this particular time, I wish to thank everyone. I appreciate you being here, and I wish you all a good day. Thank you.